going to talk about business structures today, Ashley. So how about we start with directorships?
Yep.
Now, in my experience, the most common sort of business structure I see is for a family business. And that's where both the husband and wife are the directors of the company, and they're both also shareholders of the company. Now, we've spoken about this before, but for the benefit of our new attendees today, our new guests, could you just tell us why that's a bit of a big deal?
Look, I'll start by saying that this isn't just for the new attendees. I think it's something that we need to keep reminding ourselves of, because it is very difficult sometimes to get people to understand why they should. So the real problem with having dual directorships is that directors can be exposed to director penalty notices through the ATO, and given last year that was expanded now to include GST, as well as the super, PAYG, wet tax, all that sort of stuff. It's a bigger exposure now. You also have whoever's a director of a company can be exposed to personal guarantees, and then those personal guarantees can have capitable interests, which then have impacts on homes. So the flow-on effect, where you have both husband and wife as director, then both of them are exposed personally to all of those risks that come about from running a business. And we talked previously, Phil, about how the corporate veil has basically been destroyed. The more people are on as directors, the more impact that flows through to the individuals.
Now, they're nasty things, those capitable interest clauses. I remember when I first joined Jonge, they were pretty rare. You really only saw them in the construction industry and in the trades industry, but now they're virtually in every credit agreement that a guarantor has to sign.
Yep.
Yeah. So you're better off only having one director, Ashley?
In my opinion, I guess primarily we're talking about businesses that are mum and dad businesses where it's only within the one family of the ownership. Definitely only have one director where at all possible. So the legacy of having both directors, I guess, is twofold. One is that in the very early days of companies, there was a requirement to have two directors on there. That hasn't been the case for, I think, a good 25 years, but the legacy thought of that being there still exists. And the other part is that there is a belief in family units that both should be in control of the family business, but that's better to be done through shareholding than it is through directorships, just to protect that risk area. And at the end of the day, we just don't need both people to be exposed to director penalty notice and personal guarantee exposure where we can avoid it.
Okay. Now, you mentioned the family home and how that could be exposed to risk. Just as an example, let's say that the husband is a director and the wife is not. How does that help?
Well, I probably should take a step back before I just answer that, Phil, and just to talk about, when we talk about this sort of stuff, we're actually talking about it. I like to use the example of Stephen Covey's book, The Seven Highly Effective Habits, and they talk about starting with the end in mind.
Yeah.
Now, for you and I, we live in a world where we're talking about what happens when it goes bad. So starting with the end in mind is, from our point of view, and the basis of the conversation today, is when that end is not great. You know, we all go into business hoping that the world's going to take on fire, we're all going to make millions of dollars, but a lot of it, you know, unfortunately, that's not as regular as you want. So the premise of today, I guess, Phil, is we're talking about it when that end is going the wrong way and having some protections in place for that. So coming back to your question, where you've got a husband as the director, and we're talking about if that husband was forced to go into bankruptcy because the business failed and he has personal guarantees. When we look at that, the trustee in bankruptcy is only interested in what equity is in the home. And and it's only the equity related to the bankrupt or the person that they're responsible for under their trusteeship.
Right.
So if you've only got one director, then they're only entitled to look at the equity of half of the house where a house is in joint names. So that's it's a very significant difference for a very minor change in the paperwork to take out half the equity in a home.
Okay.
And that's primarily where that comes from.
Now, I'm sure a lot of our audience today will already have lots of cases where they've got clients out there and the husband and wife are both directors. They both sign personal guarantees. Is there anything they can do about that now, or is it too late? Is it game over?
Absolutely, they can. There is a process, but absolutely something can be done about it. So I guess if we talk about there being one spouse who's the risk taker, and then we determine one spouse not to be the risk taker, then the spouse who's not the risk taker should resign straight away.
Okay.
But resigning in and of itself doesn't solve all your problems. So when you resign, there will already be in place a number of issues around personal guarantees and credit applications. The resigning spouse needs to then do what they call determine their guarantees. And what they need to do is they need to write to all of their creditors and say that I've now resigned, I'm determining my guarantee. And for any new debt that's come about by the company, I will not be responsible for given this determination.
Right.
Now, it doesn't get rid of the old debt or the responsibility to the old debt. So because that was signed up before any notice was given. But if you do it after the event, if you do it once you've determined the guarantee, then there can be no further debt attached to that person.
Right.
That applies similarly to for DPNs as well, or the director penalty notices. Once you resign, you can't be made responsible for future tax debt, but you're still responsible for the old one. So it's about a process of drawing a line in the sand where you've already had this other stuff in place.
Now, Ash, as you know, I used to work for a major bank for a little while, but only for 29 years, mate. So I think a few people in our audience today may have heard of what's referred to as the rule in Clayton's case.
Yep.
And I'll point out that you can determine a guarantee that's provided to a bank as easily as you can determine a guarantee that's been provided to a trade creditor. Now, what the rule in Clayton's case says is that any repayment off that account is the repayment of a debt, and any credit extended under that account is the creation of a new debt. So once the guarantor has determined their guarantee, the payments would be applied to the old debt. And if that creditor continues to provide credit to the business, like giving them stock on terms or whatever, it's replaced by new debt. And that new debt only has the one guarantee attached to it. And with the ATO, while they're not bound by it, the ATO's general policy is to apply any payments it gets to the oldest debt first. Now, it doesn't have to, but that's commonly what they would do. And in the same fashion, over a period of time, you can cycle out the ATO debt that could attach to the resigning spouse's director's penalty notice, and you can cycle out the trade creditor debt that would apply to the determining guarantee spouse, if that makes sense.
Correct. Yeah.
All right. So that's all good news. Even if people in the audience today have clients that have got this set up, it can be unwound.
Yep.
What about
before you move on, Phil, I think the other important thing is that we are talking about this for husband and wife,
Yes.
but it does apply when someone, and we're seeing a lot of this in the marketplace now, where someone's retiring and leaving the business for someone else. I've got an example from a couple of years ago where three brothers were running a business. They were all directors. They had a falling out. Two of the brothers left, but did nothing to determine their guarantees.
Right.
3 years later, he had to put that company into liquidation, and all the creditors were able to still use the guarantees of the past two directors as well, the past two brothers, which then created a whole new battle between a family that was already broken. So it's really, really important that as the people online who are advising people, if they're getting out of a business, this process still needs to be done. And it needs to be done well documented so that if it does become a problem in 3 years' time, you've actually got something to fall back on. So we're seeing a lot of that now as well. So it's really important that that's taken care of at that point.
Really good point, Ashley. So we've spoken a bit about guarantees. Now, in our example of a common business structure, the husband and wife jointly own the house, family home. What can we do about that?
Well, again, I spoke earlier that we're looking at it from a trustee's point of view. So the trustee in bankruptcy is only interested in the equity that's in the home. So if you only have one director, then you have the equity issue that's there. But that director that still remains, the non-risk taking director, sorry, I just had Linda ask a question. Yes, Craig is still there. I need to turn up my pop-up box. The wife or the non-risk taking partner can actually buy the equity in the home off the other person. So you've got to go through a process again. Nothing's just here, we do it and think about it. But there needs to be a valuation of the home done, the equity determined, entered into an agreement to purchase that equity. And that can be done over a period of time. So it can be set up as a 10-year process or a 5-year process, or if you have available cash, then you can do it as a lump sum purchase. And then that equity that would otherwise belong to the risk taker can then still flow through to it can be purchased by the non-risk taking partner, and they can then own all of the equity in that home.
Okay. When you do that, is there any other issues that you need to take into account to make sure that home's protected?
Well, I mean, you can put a caveat in play, so that the caveat to register that interest in the equity over time. One of the other important things is that when that sale has occurred, that there is the transfer of cash from the non-risk taking equity to the director in making the sale. We need to show the physical cash, because if you do get into trouble and there's a trustee in play, we need to be able to document and show the documentation where the money has been used to spend and pay that through. So it's really important component of it.
So once I do that, I've documented it all. How about the loan payment? Like you got a home loan? What about making the loan payments in the future? We just keep doing that as we normally have?
Yeah, and look, this is probably even a bigger issue than just in this case. But once you do that, one of the critical things, and we see this a lot, that people advise to move a house for love and affection purposes, move it into one person's name. I mean, that's a whole seminar why that's a really bad idea. But and I think everyone should be aware that moving a house for love and affection is no protection whatsoever. So if a house is in a wife's name and it's been transferred for love and affection, in bankruptcy, that won't hold up, even if it's 15 years ago. One of the things that is also really important is whoever is on title is the only one paying the mortgage. So quite often we see scenarios where you've moved it into the wife's name, and for the ladies in the room, I'm not trying to be sexist, it's just easier picking one or the other. So if the house is in the wife's name, the wife must pay the mortgage. If the husband is still paying the mortgage through the business or through the money that's coming out from there, then he actually starts to create an equitable interest in the home, even though he's not on title. So in bankruptcy, the protection, I can't tell you the amount of times I've sat down with a client, and Phil, I know you've had the same issue, and they go, no, my house is safe because it's in my wife's name. Who's paid the mortgage? Oh, I've been paying the mortgage. Sorry, it's not. So there is a whole process that for it need to be done correctly. So that paying the mortgage by the person who's on title or who owns it via the equity is really, really important.
Because effectively, if one party makes the loan payments, it could be argued by a trustee in bankruptcy that they have reacquired or acquired an equitable interest in that property.
That's correct.
And the trustee wants equity. That's what he's mainly focused on.
That's the key.
Right. So what we're talking about here is legal interest and equitable interest. So legal interest is the name that's on the title deed. The equitable interest is who owns it, like who actually paid for it, who's actually got an interest in it. Now, doing a sale of the equity and just leaving the title deed in joint names, because let's face it, sometimes you may have to because the bank might be involved.
Yep.
And it might be too complicated to get the bank to change it all. But if I've got the if I've got the property in joint names, just selling the equity, how does that relate to a creditor putting a caveat on the property? Does that work?
No. So that doesn't help, and actually it is a very problematic component. So to beat caveats, you do need to change the title, and that has some ramifications, as you said. If you've got a mortgage in place, you've got to get permission from the mortgage holder to move it. Now that's achievable. Yeah, I would say
some states.
Yeah, I'd say it's more likely than not, particularly if you're up to date with your mortgage.
Yeah.
But you have to go through a process with the bank. There's also stamp duty implications depending on the state that need to be considered, because you are doing a sale, not a love and affection transfer. And again, different states have got different rules on that. And we should stop calling it love and affection anyway. It's claiming your equitable interest in the transfer. But if you want to protect against caveats, it needs to be in the non-director spouse's name, because otherwise you're still showing a registered interest in the property, even if the equity supposedly isn't there. And once you've got a caveat on title, you've got extra problems and fights that you need to deal with.
Yeah, I've had that exact thing on a client of mine. So even if the current structure is that the husband and wife are both directors, they're both guarantors, and the house is in joint names, it can be fixed.
Absolutely.
And really, the time that we have right now, with the ATO being pretty passive about things and not a lot of pressure on a lot of businesses to actually do anything right now, this could be a great time to make those changes that are going to bulletproof that client for the future.
Yeah,
that are going to
absolutely
protect that asset and protect the family home, and do it now while you've got the time to do it. So look, that's good news. No matter what the situation is, there is a process to go through. It's going to cost a little bit of money. It's going to take a bit of time, but it can be fixed.
Look, it's an insurance policy, Phil. I think for businesses that are in good states at the moment, or in that semi-flatline state where they're waiting to see whether things are going to come back to normal or go the other way, and there's all these terms and acronyms that everyone's using at the moment, it's a good insurance policy to protect it in case things go the wrong way. And that's looking at what's the end in mind. It's just a protection and insurance policy.
All right, thanks for that, Ash. Now let's move on a little bit and talk about trusts. Now I know we've got a lot of expert people in our audience today that know all about how trusts work, probably better than you and I do, but we've got a number of people from different industries with us today, which is great to see. Could you just give us a brief overview of how trusts work?
Yeah. So for the purposes of our conversation, we're really talking about trusts as a trading trust. So they're often used to hold a trading business in them. And every trust must have a trustee. And it's the trustee that is effectively, even though a trust may operate, all debts are incurred by the trustee. Now, there's a right of indemnity that exists for the trustee from the trust assets.
Right.
If the trust doesn't have any money or assets to pay the debts, then it can be left in the trustee's responsibility to deal with.
Okay. So hang on a minute. If it's legally incurred in the name of the trustee, what happens when an individual, like I'm the trustee of my trust?
Well, you're responsible, Phil. So it's your debt. Yeah. So, and I think there's a real misconception that occurs in there, is that if you've got an individual trustee, it's the individual that holds it. So all the tax debt of the company, all the personal guarantees of the trust. Sorry, I shouldn't say company.
Trust.
All the ATO debt of the trust, the personal guarantees of the trust, all tie back to the trustee, which, if you're an individual, means it all sits on you personally. Now, even though you get
sound of that,
well, even though you get all the tax benefits of distributions and all the rest of it, that's at the bottom end of the trust, not the top end. And so there are a lot of tax benefits, and we've got way too many experts here today that I'm not talking tax. But again, the risk component, with the wrong end in mind, it's the trustee that's the real issue here.
So you're recommending that people should always have a company as a trustee?
Look, again, from a protection point of view, and there's so many components to advising people on it, but from a protection point of view, always have a company. Don't have an individual trustee, because there is no risk protection having an individual as a trustee of a trust. At least with the corporate veil of a company, there is some further protection that you would get as the trustee, but which doesn't exist with individual trustees.
Okay, so what do you think? I know that there are individuals out there as trustees of trusts, right? Yep. You and I have both seen them. Why would people do that?
Well, partly it's going to be cost. One of the big issues is that obviously if you start up a company, that's an extra cost when you're setting up a company trust structure. And new businesses, when they start up, like sometimes they start up as sole traders, and then they get a new advisor, and then the new advisor says, oh, you should be in a trust. And then I can do a trust two ways. I can do an individual trustee or corporate. I'll do the cheaper option. So partly it's a cost factor.
Yep.
The other part is that I think a lot of people actually look at it from the tax benefit point of view, not the risk point of view. I keep harping on it, but it's which end are you looking at in terms of what happens if things go wrong?
Yeah.
Let's face it, every businessman's the most optimistic human on the planet. So
have to be.
You're never going to have a problem. Everything's going to be okay.
Yeah.
I don't need to worry about that risk protection because I'm going to make plenty of money.
Yeah. My father was a self-employed businessman, and one of his mates said to him one day, geez, you're lucky, Bill, you don't have a boss. He said, are you kidding? The tax man's my boss. The ATO's my boss. The my boss. I got more bosses that I could poke a stick at.
Absolutely.
As you said, we're not going to harp on about the tax advantages of a trust. We've got enough smart people in the room. They already know what that's all about.
Yep.
Another reason can be that it's good for continuity, that the asset's owned by the trust rather than an individual, and that trust will survive past that individual. Now, let's talk a little bit about shareholdings. Is there any advantage in having a company as trustee of a trust as the owner of the shares in a business?
Well, again, yes. The advantage of having the shares in the trust is they're not owned by an individual. So if an individual director gets into trouble through personal guarantees or whatever, and they need to go bankrupt, they don't own the shares.
Right.
So therefore, you might need to change directors, you might need to do a few things like that, but they're not an asset of the individual, and assets of the individual are what a trustee in bankruptcy is interested in.
Right.
So having the shares owned by a trust means that they're not in that person's hands.
Okay. So some good reasons to use trusts for asset protection as well as the obvious tax
absolutely.
Benefits. Let's take it a step further, Ashley, and talk a little bit about asset holding entities. Can you just give us a bit of a rundown on what that is?
Well, it's pretty logical from the words, but I guess an asset holding entity, it sort of seems to go in and out of flavour over the last 25 years that sort of I've been looking at business structures and all the rest of it. But an asset holding entity ideally is an entity that owns all of the assets of a business, which is separated from the trading entity where all the risk sits.
Right.
So we hold them separately so that they are protected from the risk of the trading entity. That only works, though, if you've got perfected PPSR securities, particularly in the last 10 years since PPSR has come into play.
PPSR. So you've got to have your registrations correct. What are we talking about there, Ash?
Yeah, look, PPSR, has been around for about 10 years now, and I think it's still completely misunderstood. But if an entity owns an asset who then gives it or lends it or leases it or rents it or just gives it use of, if that other entity is using it, and they need to perfect a security that says that that's my asset.
Right.
In the old days, ownership used to determine. So you take registration of a vehicle. If it was registered in your name, it was your car. It didn't matter who had it. Now, possession is the critical factor, and particularly in an insolvency scenario. So if I rent a truck, which is registered in my name or registered in an asset holding entity, but I rent that to another entity, being my trading entity, that trading entity goes into liquidation and it's sitting in its site at the time.
Yeah.
Liquidator potentially can take it if it doesn't have the right registrations.
Is that right? So even though it's owned by another entity, if it's in the possession of a trading entity and a liquidator is appointed and he walks in there on that day and it's there, unless you've got a PPSR, he can just take it. Even though
has the ability to under the law. Yeah.
Wow.
Yeah.
All right. Now, I'm sure there's a lot of people in our audience today, again, who already have clients where a different person or entity owns the asset, but it's being used by a trading business or another company. What can they do if they don't have those PPSR registrations in place right now? How do you fix it?
Yeah, well, again, process.
I love process.
But what the first thing that needs to happen actually is that the asset holding entity needs to take possession of all the assets back.
Right.
So there needs to be a clear retaking of possession of the assets, enter into a new agreement with a new PPS lease, for instance, that may be in place, or whatever agreement you decide to use, and then released or let, and then possession provided over to the new entity again.
Okay.
But if you don't take the possession back, then the PPS leases may not look like they work.
Now, I think under the legislation, that's actually called perfection of a security interest by possession.
There you go. That's why you're the compliance manager.
That's why I'm the compliance manager, mate. I've got all the big words. So you take it back and then you start all over again and you start fresh.
Yep.
Let's look at a different situation. So now I've got a trading business and it does own all the assets. And as you've said, all those assets are exposed to the trading risk of that business. What would someone do if they wanted to set up an asset holding entity, but it's not like that right now?
Well, it's sort of like a mini restructure, I guess, is that there needs to be a sale agreement. The new asset holding entity needs to buy it. And there needs to be valuations done. And we've got really good valuers I can see on screen there as well.
Yep.
Welcome, Jeff. But so all the assets need to be valued. And then we need to take into consideration whether there's finance involved in that and whether they've already got registrations in place. Mm-hmm. They then get sold across to a new entity. Now, that can be done under a vendor finance terms. And that can be done so that it's paid off over a period of time. Or again, if you've got the cash, you can do it straight away. And then that new entity then enters into a lease to release the assets back to the entity that just bought it off.
Geez, you're clever. You got an answer for everything, mate. I'm trying
Your
to
idea,
put you on the hot seat.
I just implement it.
Yeah, trying to put you on the hot seat, but you got the answers. So again, it can be fixed.
Yeah.
Give us an idea of, firstly, a couple of things. What other issues do you need to consider? And why don't people use asset holding entities all the time? If it protects the asset from trading risk, why isn't it just the way things are done?
Yeah, well, I think the first one, again, it comes back to costs. So, I mean, you're running, at a minimum, you're running two entities in a structure like that. Mm-hmm. So therefore, there's two sets of financials, there's two sets of record keeping that needs to be done. Yeah. There's some other practicalities around if there is a lease agreement in place, then each month a payment needs to be made. And if the business owner is not savvy around these things, then I've seen a lot of cases where people have put it in place, and then because no one actually transfers the rental payment every month, yeah, you actually create a new problem. So then you have advisors go, look, you're just creating a bigger problem than you had, so let's merge it together. Yeah. But often I find cost is the big issue that stops people doing it. And then the process. There's like if you set up, as I say, if you set up a lease agreement, each month you've got to make a payment, and it's got to come from the trading entity back to the asset holding entity. Because if you don't, then it can be argued that it wasn't actually perfected and actually the process run properly. Or you create a loan account, which is another loan account.
Yeah. Tell you what else I see is that people that have already got asset entities set up, just go out and buy a new car in the name of the trading entity without even telling their accountant. And before you know it, you've got assets held by both entities, and you've got to start the process all over again. So,
yeah, we see that a lot. Yeah.
But again, these things can be fixed and they can be worked out.
Yep.
All right, Ash, time to get a bit fancier now, mate. So you better put your thinking cap on.
Right.
License agreements.
Yep.
What's a bit about license agreements? What's the inside word on how they work?
Yeah, okay. So license agreement, I guess when we talk about asset holding entities, Phil, we talk, or most people think about the primary asset being physical assets.
Yeah.
But you actually, you can also have goodwill owned by the asset holding entity, goodwill and all the IP. So the actual trading name of the business, the customer lists, any technology that's involved in running the business, all of that sort of stuff can actually be part of an asset holding entity as well.
Right.
So a really smart way, and again, it's a little bit more complex, but when you're looking at asset protection, that's what you often need to do, is that by having a license agreement, you actually license the right for another entity to run the business, right, using the IP, physical assets, all that sort of stuff, to another entity. Very similar to a franchise style agreement, where someone comes in and buys a franchise, they get to look like they're a whatever the franchise might be, let's just say a coffee club. So you can look and smell like a coffee club, but really you don't own anything, and the coffee club can take that back whenever it wants. So you can do that within your own little small business. So you can actually have an asset holding entity that also license out the right to run the business, but it keeps ownership of the trading names, it keeps of the websites, email addresses, all that sort of stuff. And when a default occurs, you have the ability to take it all back.
Okay. So now we're talking. So that's really what we're saying the potential benefit is. Tell us about what happens. There's trading risk out there. Now I've got all the assets and the goodwill and the IP and everything owned over here.
Yep.
But my trading entity over here gets into trouble. What happens next?
Well, so if you're in that case, and again, the setups need to be right, but if you've got that license agreement, the head license or the license agreement owner can actually just effectively issue a default notice and say that you are no longer running the business the way I want you to, or looking after my brand properly, and take it all back.
Okay.
So you can just take everything back and bring it back into the asset holding entity, and then that asset holding entity or the license owner, licensee, can then issue a new license to a new entity to then continue to run that business.
Or even sell it off to a third party without any immediate pressure.
That's correct.
The pressure's on the trading entity, not on the licensing entity.
That's correct, yeah.
Okay. So right now, if that happened and you didn't have a license agreement in place, you'd have to go through the process of doing a restructure. So that means getting everything valued, whether there's assets, get the goodwill valued, set up a new trading entity and sell it across for a fair commercial value.
Yep.
If they've got a license agreement, though, they can just cancel the license and move on. Is that right?
That's correct. Yep.
Okay.
Yep.
But I assume that just because you can do it doesn't mean you should, Ash.
There's always certain things that need to come into play with directors' duties and doing following all the corporate rules and regulations that exist. Mm-hmm. And the other reason is obviously if the business isn't viable, there's no point moving it around if it's not viable. So if it does need to be shut down, then it needs to be shut down. But yeah, no, it's a very useful tool, and I know certainly if I had more clients coming into me when they're in trouble, saying I've got this agreement in place, it makes it a lot easier to protect them, and generally a lot cheaper as well.
I think a lot of clients that have had trouble have then adopted this sort of structure in the future, just to make sure that it doesn't happen again.
That's correct. Yeah.
Now, we've spoken a lot today about asset protection and looking at the scenario of when things go wrong. And as you said earlier, nobody sets up a business thinking it's going to fail, because everybody works really hard and they're passionate about their businesses and they're optimistic.
Yep.
Having one eye on a plan B is certainly a good idea. Because I'll say this, Ash, when I bought my house, I never imagined it was going to burn down, but
No.
I sure as heck went out and got an insurance policy in case it did.
Yeah, that's right. Yeah.
Some of the things we're speaking about today is really, in effect, it's a form of insurance. So we've covered a lot of ground today, Ash. Could I just ask you to give us a brief recap of the major points that we've spoken about?
Certainly. And I think I'll also say to the crowd now, if anyone has any questions or comments that they would like us to talk about, while I run through the list again, you're welcome to start putting them in the chat box, or get prepared to put your hand up and then we can talk through it. But in really simple terms, what we're talking about is that we believe that it's important to have one director, not two. That we move the family assets to the non-risk taking spouse. And I often joke, and a number of the people online here would have heard me talk about the fact that I'm one of the directors here at Jonge, so I'm the risk taker in my family. What assets we have, my wife owns. So therefore I've got to be a little bit nicer to her every day.
We're nice anyway, Ash.
But very much it's important to have a risk taker and an asset holder in whatever structure you can. If you need to, you can equity can be transferred through a sale of equity, as well as looking at doing the change in title for protection purposes. Trusts offer good protection, but making sure you have the right trustee in place is critical. Really not a fan of individual trustees from a risk perspective. So there's a lot of other perspectives, and advisors need to weigh up all the components, but from a risk perspective, it's certainly a bit of a problem. Big fan of asset holding entities, but as long as they're done correctly and that we have the right PPS registrations in place, because otherwise they do fall apart. And next level, and a level that I would love to see businesses, particularly if they're in a risky industry, and let's face it, at the moment, anyone could be in a risky industry, is license agreements. So they are a really, really good tool, completely underutilised in the Australian market, but it's a really good opportunity for someone who, let's say now they're sitting at that borderline phase that my business is either going to fly or it could fall, but I really won't know until what happens on the other side of COVID and the pandemic issues and government issues and how they're dealing with it all. Now's a really good opportunity to look at putting some protections in place to seek against that. So talking to us about those options is really valuable now while we have a lack of pressure. And that's pretty much, I think I've covered everything that we talked about, isn't it?
Yeah, the main thing, and I'll just reiterate again, is that no matter what the structure is right now for our audience's clients out there, if they'd like to make any of these changes, it can all be fixed. It can all be changed. You just need to run through the process. So, Ash, I know we've got a number of new guests joining us today, and that's great to see. Maybe if you could just spend a minute, just give them a real quick outline of the way Jonge operates, and then give us your final words.
Yeah, so for those who don't know, if you do have a client that you're a bit worried about, what we do here, and it comes from the history of how Hank got involved, or started the business in the first place, is that we will sit down with you and your client and have a look at their scenario at no cost to the client. So you can come and sit down with us. We'll have a look at the situation. If we believe it's necessary, so if there is a reason for us to write a report, we will then develop a strategy on how to help your client and help them guide their way through the process. And all of that's done at no obligation and no cost. So clients pay us to implement the plan, not to actually come up with the plan. So it's a really good, we're seeing a little bit of it, quite a bit of it at the moment, where we're being brought in to have a look at what happens if it goes bad, develop a plan B. Some of those plan Bs don't need to be implemented straight away. Other times they do. But we provide all of that first obligation and cost-free to the client. The other thing that I'm very passionate about is that we like to be the person that you can call and go, should I even talk about this with someone? So if you have a client that might have any one of the issues that we've talked about today or any one of 100 other issues, don't be afraid to jump on the phone to myself, to Phil, to any of our strategist team around the country and just ask the question. I've got this issue. What do you think we can do about it? Do I need to do anything about it now? We want to be a resource to you as our referrer base, as our partners, I guess, in this, so that we can actually help. And that way, if we're a little bit ahead of the game, when something does go wrong, we've actually got a little bit of heads up on how best to deal with it. So please use us as a resource for knowing where to go. In wrapping up, if anyone has any questions, please, you can either put your hand up. Elise, our national guru marketing person, will keep an eye out for hands because I don't know how to do that. But if you want to type a message in, then you can certainly do that as well. I think there's a survey that's about to pop up on the screen. Again, it's nice to know whether you think that it's what you're looking for or what you like. There it is. It's popped up now. So please feel free to say nasty or nice things. I prefer it nice, but we'll take nasty. And I think just for everyone's heads up, I think Phil's decided that he deserves a holiday. Yeah. So Phil won't be with us for our next webinar, but I'm very excited that we've got a guest speaker coming in, Mike McHenry from Seamless Self-Managed Super Funds. It's a national business, and he's coming in to talk a little about some non-negotiables for business success and to talk a little bit about what the experience and what they do in the SMSF market. I have to say that very slowly.
It's hard, isn't it? It's harder than it's down.
But it will be, rather than us talking about all the negative stuff, we're going to start talking about a bit of positive stuff on business development and how to grow a business, dealing with culture, all those different types of areas that we all have to deal with as business owners. So I really look forward to that one next month. And I think that's about it. Doesn't look like we have any questions. Thank you, Vicky, for your kind words.
Yes, thank you. You've done too good a job explaining it all, Ashley. Yeah.
So if there doesn't appear to be any questions, so on that basis, I think we'll wrap up and let everyone get on with the day. I thank you all for giving me and Phil and the firm 45 minutes of your valuable time.
Thank you.
I think if there's one thing I will say is that for those that are under the stress of lockdowns, or even if you're not in lockdown but you're feeling the stress, if you just need to reach out and talk and have a chat, most of you would know. Some of you may not have heard me speak, so you may not all know. But I'm very passionate about making sure that people are okay. And please don't be afraid to pick up the phone and just have a chat. Keep yourself safe, keep yourself well. Life is very interesting at the moment, but at the bottom of it, we're all here as people to try and look after each other. So have a great month. If I don't talk to you in between, and thank you all again for attending.
Thank you.
All right. Cheers.
Bye.
Bye.